American Advantage Law Group is proud to bring you this webinar. This presentation will discuss contract negotiations, how to go about them, how to get the best deal, and how to avoid some of the common pitfalls. So there's a couple things you need to consider before going into this. First is the collective bargaining agreement. You also want to look at the standard player contract. You want to examine the league bylaws and constitution. You want to look at relevant court cases dealing with contract negotiations. You want to talk about the contracts of similar players to you, and you want the information of those players who are similar to you, their salaries and their benefits. Once you have all this information, you should go ahead and proceed with looking up things like potential contract guarantees, incentives or bonus provisions, no trade or no cut clauses, any bonuses you get for signing, injury protection provisions, disability insurance, and renewal contract provisions after your contract has expired. There's a few important terms to know. The first is free agency, or the amount of restrictions that are put upon you through the contract. You also want to think about the salary cap, or how much money you could potentially make as the maximum amount of money from the contract. You also want to look at the rights of first refusal and what the impacts of your vetoing some sort of contract clause would be, and whether or not you have the ability to. There's 6 common pitfalls. The first is poor planning. The second is thinking that the pie is fixed, and we'll talk about that. There's also failing to pay attention to your opponent and paying too much attention to the anchors or the parameters that are set. You also don't want to cave in too quickly, and lastly, you don't want to gloat if you got a good deal. This is very important, and we're going to talk about all of these in turn. Planning is very important. Successful negotiators make detailed plans. They know their priorities and alternatives should they fail to reach an agreement. They know their own bottom line, and they know at which point they will walk away. They also know that there are time constraints and whether or not this is the only time you'll see your opponents in negotiation, and whether you should save your bargains for later. After you prepare your own agenda, you have to outline your opponent's agenda too. What are their preferences, alternatives, and bottom lines? Once at the bargaining table, you should test your hypothesis for their priorities in order to determine what they really are. The pie is usually not fixed. You may make this mistake when there's a congruent issue, when both parties want the same thing. For instance, in the case of a salary bonus, a salary raise, or a bonus, you think if one goes up, the other must go down. That's not necessarily true. Do not think just because you can't get anything, you'll have to take the middle. You can't get everything that you want to acquire in the process of negotiating the contract. It's very possible for you to get everything. You need to pay attention to your opponent. Negotiators need to analyze the biases of their opponents brings to the table. One way to get inside your opponent's head and influence his attitude is to shape the issues for him or her, a technique called framing. If you get the opponent to accept your view of the situation, then you can influence the amount of risk he or she is willing to take. Anchors. Anchors are a part of the bargaining dynamic known as anchoring and adjustment. This involves clearly setting the parameters for negotiations. This means reasonable high and low starting points for the buyer and seller that must be set before negotiations can begin, in order to create a reasonable point in which you two can negotiate. But don't cave in too quickly. Accepting a well-priced deal too quickly can cause anger on the other side too. Even if the price is fair, always offer less, if only to make your opponent feel good about the deal and make them work for it. You may come at the full price in the end, but at least your opponent will feel as if they made you work for it. You shouldn't give anyone their first offer because it makes them crazy, makes them untrustworthy as well. Finally, when you have cut a sweet deal, never do the dance of joy in public by turning to your opponents and telling them that you would have done it for less. This will only drive your opponent to extract the difference from you sometime in the future in later contract negotiations. You should never gloat. You should always tell them that they made a fair deal. So, feel free to join us on the LinkedIn network, or email us at americanlawfirm411@gmail.com, or you can stop by our office at 3848 Campus Drive, Suite 206, Newport Beach, California. You can call us at 949-863-1888. We can help you with the contract negotiations. We'll get you the best deal possible. We have a lot of experience, and our lawyers are definitely full.